Good evening, Mr. Chairman, members of the committee. Bryan Blevins on behalf of the Texas Trial Lawyers Association, and we too are opposed to House Bill 2512. I agree completely with Mr. Cherry of Boda and Mr. Christensen, although I find that odd for me to do that. You'll have to excuse me if I stumble there. But in reality, I do want to bring up a couple points that I don't think have been made yet, and that is one, there are some significant ethical problems that I think this creates for the original attorneys in the case. Because as a part of this process, one, you would have to advise your client about that option in an informed way. Very few of us in the trial practice are going to be involved extensively in collaborative law, and therefore we may not know or be able to fully advise our clients. Under this bill, if you were to proceed with your client into collaborative law and it failed, because again, it's voluntary entry, voluntary termination. If it were to fail, the collaborative lawyer cannot continue to participate in a proceeding outside of that collaborative matter. Therefore, it conflicts the attorney off the case. And so consequently now you've put the existing lawyers in a conflict on how to advise their client, the risks of advising their client on going into a collaborative process where either you would have to hand them off to a collaborative lawyer or risk the fact that if it all breaks down, that they would lose the lawyer of their original choice. So I think there's some ethical issues there. Again, to sign that agreement, informed consent would be required. Again, is there sufficient participation and experience with collaborative law in this whole group of lawyers who participate in that? I would also go back to Mr. Schofield's point in that not only could we find judges who look at you askance because you haven't agreed to participate in it, but let's go the other way. And the judge who gets mad because you entered into that agreement and 3 years later, his proceeding is still stayed. And you're sitting there in collaborative law. I'd also want to point out, although I'm not suggesting that any lawyer would do this, it's certainly possible that parties from different sides might enter into an agreement before suit is filed to have a collaborative law agreement, which would then, as Mr. Cherry pointed out, extend the statute of limitations forever. As to all parties wherein a suit has not been filed and therefore the other parties don't even know it exists. That would be an unintended consequence. I'm tempted to suggest that the oath of civility will help remedy any other needs for this bill, but otherwise I'm happy to answer any questions that you might have.
Any questions for Mr. Blevins? Appreciate you being here.